Good morning. We're on the recording case D434927, Shanna Soares versus Yukio Soares. Okay. Counsel, your appearance for the record.
Amanda Roberts, bar number 9294, on behalf of the defendant who is present in the courtroom.
Okay, and your name for the record?
Shanna Soares.
Okay, and this is on today for Dad's amended motion for order to show cause to compel Mom to pay orthodontic expenses to compel compliance in filing financial disclosure form, recalculate child support for fees and costs, and Mom's opposition and Dad's reply. The court has read all of it, of which, Ms. Roberts, your motion was extremely long, past the 30 pages.
But it's just such a long procedural history because you're
I could tell that, counsel, and I did read it, and my law clerk briefed it, and we went through a lot of it. And I also listened to the audio that was submitted in his exhibit. You had that audio, right, Mom?
Yes.
Okay. There's some issues. We're going to have some conversations. This court is not pleased with you right now. So you understand, after reading all this, we're going to have an education for you on how things work. Okay? Okay, Ms. Roberts, it clearly is your motion, and I saw that there's actually 15 counts of order to show cause that you requested.
we submitted the order to show cause to the court, Your Honor. So this is
I
the
had
issue.
it.
Procedurally, these contempt things continue to happen. They were started with Judge Potter. They've continued with Judge Steele.
You can have a seat, Mom.
And despite being admonished by both Judge Potter and Judge Steele at length, including loss of certain legal custodial rights, Mom continues in the behaviors, which is alienating behaviors that are harming my client's relationship with the children.
Terribly so, from what I listened to in the audio. The fact that you discuss emancipation with your child, and you discuss whatever you can do to get away from your dad, has got the court really, really concerned. So I clearly see that part, Miss Roberts. You can continue. But I want Mom to understand, I listened to every word that I could hear. I mean, it was hard with the music background that your son recorded. Shame on you. We're going to have a big discussion. Proceed, counsel.
And so this is continuing to go on. And originally, Mom had primary physical. We got to the point that Judge Steele modified it, and we came up with a stipulated agreement for joint physical. But I really am concerned that Mom has some mental health issues, Your Honor, because this has been going on for years, and we don't know what else to do. Because the longer this goes on, the more the relationship is impacted to the point that it's affecting my client, his spouse, the other children in the household, and these boys. So something drastic needs to happen. She already was found in contempt by Judge Steele. We had this whole Shane Weinset provision in place. I just don't know where else to go with this. And I feel for him because it's a constant issue. And trust me, he doesn't want to be paying me to come back to court, but he wants to be able to have an unfettered relationship with his children. And so that's where we're at. I know the court's read it. I won't go into extreme detail in it. But my main concern today is some kind of modification of the physical timeshare to limit Mom's contact until she can learn to behave appropriately. And I will be honest, since
I'm almost concerned, counsel, that the fact that she would do this with her son and tell him all this stuff about, oh, let's look up, oh, yay, we found the law on emancipation and all these things, concerns me so much. I'm almost tempted to issue her only visitation with him to be supervised, because I don't know that I can trust her at this point.
Well, that's what we're asking for, Your Honor. We actually think that it should be supervised with somebody either like Nick Ponzo or Donna Wilburn, somebody that can ensure that she is getting, that number one, she's getting help, and number two, that she's properly having a relationship with the boys. I don't think Donna's house is the appropriate place to do it. And they're older kids.
They're too old. So
the only other option is some kind of maybe pro bono counsel, if we could find one who could supervise the visitation. Other than that, I don't know what to do. And she's already told them in October 20th, pack your stuff, you're going to live with your dad, you're never going to see me again. And that's not our goal. We don't want them to not see her. We just want them to be able to have a healthy relationship with both parents.
Well, my concern is she doesn't recognize what she's doing is actually damaging her children, and that's why I'm going to interrupt you again, counsel, just so she hears it as we go through each step. Mom, I don't think you understand. When your boys look in the mirror, they see half you, they see half their dad. Do you recognize it? I don't know if they have their dad's eyes, or your dad's smile, or your eyes, or maybe your expressions, or maybe they have one of your laugh. But when they look in the mirror, they see half you and half him. Do you recognize that, Mom?
I do.
Okay. So listen to me. I'm not done. So when you tear him down like I heard on that audio and what you've done, it's not that you're tearing down him that I'm concerned about. You guys can dislike each other till the cows come home. I can't prevent the way you feel about each other. But when you tear him down to your children that you did to Mark, you actually are tearing down Mark. And I don't think you get it. I don't think you recognize that when you say, oh, you got to get from the dad and da-da-da, all this stuff. It's like you're saying, Mark, half of you is terrible. Do you recognize that you're scarring your son that way? Do you recognize that, Mom?
Yes.
Then why would you do it? Would you let somebody else scar your son? It's like pulling out a knife and slashing him emotionally. Would you let somebody else come in and slash your son with a knife? Would you let that happen?
No.
Then why are you doing it?
I do want to say that that recording was a little snippet of a 2-hour conversation. So
That should never have happened. I don't care if it's just a snippet. The fact that it happened, and it did happen, Mom, is very concerning for this court. You still are not focusing on what I'm telling you.
I understand.
That when you say things to your boys about their dad, you are slicing them, Mom. Because really, the two important people for this court are those two boys. It's not you and it's not him. Though you guys are the ones who are having to come before me. It's those boys. And what you're doing is you're destroying their self-esteem, their self-worth. Everything that you're supposed to be protecting as a mom, you are destroying. And I need you to get that. Because we have court rules against it. EDCR 5.301 prohibits you from discussing things like this. Like, oh, we're going to go through. Just tell them that you only want to be with your dad on Friday to Sunday. That was another statement that you said in your diatribe with your son, where you were scarring him repeatedly. Those are the things you said. EDCR 5.301 says you can't talk about kids about court cases and how we're going to do stuff, Mom. You are prohibited by this court. Not to mention all the stuff in your orders that you have. I am really concerned what you're doing to those boys. You should be concerned about what you're doing to those boys. You have not obviously put together the pieces that when you talk bad about him, you're talking bad about them themselves. And I don't think you've been clear of that. Because when they look in the mirror, I'll bet you they see a little bit of you and a little bit of him. That true? Okay. Counsel, you can proceed.
So that goes to the physical custody, Your Honor. We really think that there needs to be some kind of mental evaluation of Mom. I don't know how to do that. I really truly believe that Mom has some mental health illnesses that need to be addressed, and that is what is impacting the physical custody at the present time. She has such hatred for my client. There's more audio that we've obtained since the hearing, telling him to lie and stuff. That was in the reply. This behavior is continuing even after she's got it smack in her face with the recordings, a 50-plus page motion. It still continued up until August 20th. After August 20th, they deleted everything so my client can no longer see it. But that's the reason that he maintained their cell phone records, is because this was going on with hidden devices at the time that Judge Potter was in the case. So that's the main issue. We then come to the legal custody, Your Honor. It was previously restricted. For some reason, Mom doesn't understand that. We need that previous restriction back in place. The financial disclosure form, I've been trying to get that since January. I tried to use Shannon.
Why haven't you filed a financial disclosure form, Mom?
I have.
Okay.
I have.
When did you file it? Let me look and see. Do I know?
I filed one in April, and then here's the most recent one, filed 10/18,
Okay.
2019.
And I just missed it on my list when I was going back through it. There's so much that I had to review on this that
I'm so sorry. I know it's a large
No,
file.
go ahead, counsel.
The financial issues are a huge impact, or a huge component of what's going on. So Judge Steele said, fine, get your education essentially, and then we'll revisit this. But Mom hasn't done that. So she's gotten her education completed, but she's still working minimal amounts.
Oh, I did see your financial disclosure. You're a cosmetologist and you're claiming you're making hardly nothing.
Because
Why?
I just started with my company, and since June, and I'm trying to build my clientele.
Okay.
So that's one of the issues, and we did the whole, Judge Steele had to previously impute income to her, all of those issues, and then all of the contempt. I will go over every single, do you want me to go over every single one of them for the record?
I look, there's 15 counts.
Correct.
If you just wanted to, so Mom hears it and so it's on the record, that would be
Absolutely,
great.
Your Honor. So count 1 is violation of the order filed May 30th, 2018. That's restricting my client's access to the cell phone communication with the kids.
Yeah.
Count 2 is a violation of stipulation order filed May 30th of 2018. This is in regards to enrolling Mark in a divorce counseling group at school, then purposely lying to Dad when he addressed it. So the fact that he had to go to the school and obtain the information. Mom unilaterally signed those permission slips. And I just want to be clear, it's not that my client would have objected, but again comes back to communication and maintaining this free flow of information. Count 3 is the stipulation order filed May 30th, 2018. She's continually saying things to the children, which my client has heard. We have already given her notice in writing that we are recording these phone conversations. She's saying things to them to essentially impact their view of their father. Things like, you're almost done over there, you know you can get off the phone because someone's going to be mad at us, things like that that have continued. We also have the things that she has told her to do in the reply. No, that's not specifically in here. May 30th, involving the kids in the parenting dispute. For some reason, Mom believes, and this has been an ongoing issue, that giving him notice of when she goes out of town somehow blocks his ability to do that. I don't think she recognizes that that provision's in there in case there were an emergency, either wherever she is with them or with Dad. And so what she has done is told the boys to lie about things. We addressed it in here, specifically this 4th of July plan. She's allowed on her timeshare to do the things that she wants, but he has a right to know.
So let me address that one before we go into count 5. Mom, let me explain it to you. Perhaps you're not getting it. You were living here when 1 October happened, correct?
Correct.
You saw the horrific things that happen in our own town, right? You see on the news all the time that there's events occurring, right, where people are killed, and they're in. Like a few months ago, there was 3 mass shooting situations in a matter of a few weeks with the Garlic Festival. Then there was El Paso, then there was Dayton, all these things. You recognize that, right?
Correct.
Having your children lie of where they're going and their dad not knowing where they are when they're out of town is about that issue. If something happens to you or to your kids, he needs to know where to go to find you. So telling them to lie about Logandale on the 4th of July is not okay. So if you did, and I'm not making the total assumption that'll be an evidentiary issue we'll deal with, that is not okay. You guys both need to know. You need to know when he takes them out of town. It's just a simple text message. Hey, just let you know we're out of town, we're here. It's not permission. It's just to know, because if something horrible like that happens in our state again, he needs to know where to go. Okay? Are we clear on that? Okay.
Besides the Logandale incident, Your Honor, we've discovered after October 20th that she actually took them to Arizona without notice to my client as well. Then count 5 is the stipulation order, May 30th, 2018. She contacted the police during his time for a well check. At 10 o'clock at night, they had to come into his house and view the children on a school night for a well check after it was his time with the kids for no reason, alleging that they were scared for their safety and Dad's care. This has been an ongoing issue that she has.
Trying to build fear for Dad's time.
Correct. The stipulation order filed May 30th goes into the financial disclosure form on multiple pages, and her requirement to file it and provide it to us. That also goes to the postings on social media that she's making, that she's allowing the children access to. She failed, count 7 is failing to pay the $200 in attorney fees as ordered February 1st, 2019 from the order filed July 5th of 2017 and the stipulation order filed May 30th of 2018. The next one are the additional attorney fees. Those are paid at $100 a month, and then was an increasing schedule to $200 a month, again pursuant to the orders that were filed in the case. Count 9 is again related to the stipulation order and the payments to him, and count 10 is to equally divide the cost. They agreed for Mark to get orthodontic care.
Correct.
My client then paid the initial fee. He started paying his portion. He paid the first 6 months. Mom refused to pay. In order for Mark to continue with treatment, my client had to pay it. He's been giving her the 30-day notice. That again goes to the 30-30 rule, and that's from the order filed July 22nd of 2011. He's submitted receipts to her for eye exams for Mark, Mark's glasses, and eye exams for Matthew. She's failed to reimburse him pursuant to the 30-30 rule, and that order was filed July 22nd, 2011. And then 12 through 15 go to the information that we located, the recordings and the things that we provided to the court on the video, and those relate to the stipulation order filed May 30th of 2018.
Okay, thank you, counsel. That part was all pretty clear.
So,
Mom, I have read your
okay.
Proceed, counsel. Go ahead.
Sorry, Your Honor. Okay, so then besides the contempt, the payment of the monies that are owed, we already outlined that, and then our request for attorney fees. That's where we're at in the case, Your Honor.
Okay. Mom, I recognize you probably feel like I'm being really hard on you, but when I hear audios like that from a mom who's not putting her boys first, that's concerning to me. So you understand. They have made, there's been allegations, and with substantiated allegations, at least, of what's occurring between the two of you. I've read your opposition, and basically you say that you want no change in legal custody, you want primary physical custody, and modification visitation, and modified child support. You say there's no substantial reason to change legal custody. But when I listen to those recordings, I have to disagree with you, Mom.
I didn't get those. I didn't.
You didn't have them when you wrote the op? Okay. Well, it doesn't mean that you didn't know that you had that conversation with your son, because you were the one that had the conversation, right?
Your Honor,
Yes, please.
I did feel like the conversation, like I said, yes, that part is damning, but the one part that I needed to, it was about both of us. My son was very upset with his father, me, and his school. That snippet was taken out because we were talking about it. And the end of it was the repercussions that he would, if he did want him to do the divorce, he wouldn't have his family. He wouldn't have his dad. He wouldn't have the things that we've been providing for him. So I was trying to give him a whole. And unfortunately, the whole thing was not... No.
I believe you used the word yay when you found the statute about emancipation. You were looking it up, obviously.
I was being facetious with him, and I'm sorry that it was taken out of context, but the whole conversation was him venting about everything that was going on for almost 45 minutes to an hour. Then it was this snippet of me just trying to say, okay, let's figure out what we're going to do then. And then at the end, and I get it. If that was the only thing that was heard, I would understand. But then the end of it was, is that something that you wanted to do? Is that something that you want to be away from your family? Is that something that you want to go and find a job? You know, you have to, there's so many things that you're going to do, and you're only 14. And so that whole, I feel like that, yes, that was very damning.
Mm-hmm.
But the whole conversation was a learning experience. And was also talking to him. He understands. If you ask Mr. Soares, you can ask him that Mark has been working better and working harder and understanding that that both of us are his parents. And I don't think that he's...
But your first statement to that mom was, well, do everything you can to get away from your dad. That was one of your statements in there as well. Do you recall that?
That was because it was
That was before you found the emancipation statute on your phone or wherever you were looking it up.
That's because he was mad at him at the time. And I said, go to your robotics club. Go, work on your stuff. If you feel like you're angry at him, do whatever you can to get away from your father. I told him the same thing. He gets angry with his grandma and grandpa that we live with. He gets angry with his boys, his brothers. He gets angry at a lot of things, and right now he's
14.
He's trying to figure out himself. And
You're not helping.
I understand that, but I feel like that part is not just the conversation. Nice.
Okay, that part might not be just the conversation. That's just a snippet, but that isn't the only count against you, Mom. You've heard the counts against you. The fact that you're restricting the communication of the boys via the cell phone.
The phone call's right here. Mr. Soares has an email that he sent to me stating that I made a request to do the on-time phone. Anyway, he said in here that this was his choice to not do every single day phone calls. That was his choice. That was his email. I could submit that.
Okay, well, you'll have a chance in an evidentiary hearing whenever we move forward on that portion as far as the order to show cause. As far as count 2, he says you enrolled him in a divorce counseling group without talking to him about it.
No,
What's the
Your
deal?
Honor. If he went and looked into the emails, unfortunately, or the text messages, unfortunately, Mark's phone and my phone were stolen.
Okay, first of all, it shouldn't be Mark discussing this. It should be you saying, hey, I found this thing for our son. What do you think? That's what should happen.
I sent him a text message with a piece of paper. That piece of paper was just so Mark can go to a lunch group with his friend, with several kids that are divorced, so they get to know each other. A teacher has to be in the side, or an advisor has to be in the room with them. There were about 10 kids.
Did you sign him up without Dad's permission? Did he ever say yes? to doing that?
I did sign him up, but I sent him
Did
the
he
email.
ever say yes to doing that?
No, Your Honor, but
Okay. All right. Regarding the, we've already had the conversation, you talking to your kids inappropriately. That's more count 3.
Your Honor, could I just real quick
Yes,
address
please.
that real quick? So there's another recording that we found their text messages on October 10th, when my client located this tablet at his home and asked Mark about it. She told him that they were going to use that tablet in court. That's in the text messages, and I provided the court with that. She also told him to use his cellular device to delete the text messages, and he asked specifically if he's supposed to delete the porn links so that his dad can't see it. He then asks her, "Why are you trying to make me feel guilty?" She responds and says, "Because you're not helping our situation." Presumably they're talking about the tablet and him finding it and the child giving him his password. They then go on in that to talk about.
You're telling me that you didn't text that, Mom?
we did text it, but it was
Okay.
a whole different conversation, Your Honor.
Okay, well, she's just reading to me what was text. You did tell him to delete all the stuff, Mom?
Well, Your Honor, I did tell him to delete stuff, but that's because the tablet was connected to my Gmail. There are things in there that he didn't need to have, and there's things on there that, like pictures. Mr. Soares found pictures that he claims that I took them out of. It was Searchlight, Nevada. 2.5 years ago.
Okay, well, all right. Proceed, counsel.
So these are the additional communication that she's having with him regarding these types of issues, Your Honor. Not only in text, but there's recordings during the phone conversations where she talks to him about this, and we have those as well in the recordings.
Okay. I am concerned. I am concerned, Mom.
Your Honor, I don't know how to explain to the court that I've been doing everything I'm supposed to, according to my attorneys, and then
Your attorneys told you to have conversations with your son regarding emancipation and deleting
unfortunately,
evidence.
no,
Deleting evidence that could be brought before or against you.
the deleting evidence, there's
Your
nothing.
attorneys told you this? Some attorneys told you this?
No, I apologize for that comment, but the deleting the things, first of all, his tablet cannot take porn. It's his little brother's, so it is completely cut off from everything. He was being a smart aleck. Second of all, it's only on Wi-Fi, so each person that has a Wi-Fi access is the only way he can get onto that tablet. I don't understand what he's saying. He did delete a lot of my things for work on there, and that's why I said you're not helping.
Okay, well, you'll
It
have a
was
chance to
not the
address
sa-
that. Because it doesn't, that's not what it sounds like.
That's what I'm saying. Like, there's a lot of things that I've written to my child and spoken to them that he's taking out of context because he's recording me. He's looking into we're supposed to speak freely, but unfortunately he is taking what he wants to the court.
So you will have an opportunity certainly to defend that, Mom. You'll have an opportunity. I'm going to set an evidentiary hearing to determine if I find you in contempt. Let me tell you what the issues about contempt are, so we're really clear. Because I think we're going to have to, first line, you set up some parameters to protect the boys as well, but let's
Can
talk
I
about
just
the
tell the
contempt.
court, after the reply, there's additional messages she's
Okay.
sending. This is a quote. "Before your father comes and gets you, clean everything up like you've never been there. Leave your Vans and new shoes. Leave with what you came home in. Hot Wheels, electronics, and Legos stay." These are the types of messages that she's sending, and these are regular occurrences to these children, Your Honor. This isn't
They are
a
not regular occurrences.
Well, I'm going
They
to
are
tell
not
you,
regular
so that, but
occurrences.
that did just occur, correct, Mom? You
That
did send that
occurred.
text message.
That was when he decided to leave the house and run away and call his dad.
Leave your house and go call his dad to go stay with his
Yes.
dad.
Yep.
So he's running away from your house to go to dad's house.
That never happened, Your Honor. We never received
Okay.
communication from the child that
Because
was running away.
he
Right,
did
okay.
not.
But he's running away from her house to his house, it sounds
No,
like, counsel.
Your,
That's why I was asking. I said,
He
you ran
didn't.
from your house to his house, and you said yes.
Your Honor, no. He
Take a
was
breath. We'll get through this.
No,
There's more tissue there for you.
I will do anything for my kids. Anything. I'm done. I'm so tired of being looked at as the evil mother. I have wanted nothing more than just to move on.
Well, then maybe it is maybe what Miss Roberts says is the right answer, that maybe we need to get you some help. Maybe you don't have the tools
I've
to
already
do it.
seen someone, Your Honor.
Who are you? What, you're seeing an
I've
counselor?
seen a friend who's helping me through this.
Well, a friend doesn't necessarily make them qualified to help you with
Well-
any psychological issues. My concern, Mom, is that you don't evidently have the tools. The fact that you would talk to your son about those things, that you would tell them to do these things, those are all damaging to a child. And
I
I'm
would like
concerned
to say
about the boys.
my children are saying a lot of more things to me, and unfortunately, I don't have the time to go and search things. I don't have the access to the phones because I don't look at my children's phones every single day. I don't search. I don't record. I just don't have that time or money. And my
Okay.
children are saying damning things about his house. And that's why I have asked for the past 3 times for child advocate. And everybody has denied, has either ignored or
Well, I'm
denied.
happy to appoint a guardian ad litem for your children if you pay for it. Somebody's got to pay for this stuff.
I'll
We
pay
have
for
to
it, Your Honor.
So,
I
I
will pay
mean-
for it.
I mean, counsel, I'm happy to have these boys, so you understand, Dad, your counsel probably explained it. A guardian ad litem will represent the best interest of the child and be able to tell me what the children, without making the kids come in here to be put on the stand, because we don't like children to testify. It's more damaging. We've already got enough damage going on here to those poor boys by them being told, your dad's terrible, I don't need this, to increase their stress. So that's the other potential. We could have a guardian ad litem, counsel. What are you thinking? So we can talk about that, Mom. But look, the issue is that's like paying for an attorney, and you're not even paying for an attorney to come represent you. That'd be paying for a full boat attorney costs. They charge. Their time isn't free. So that's the problem. So this is the issue, Mom. I want you to understand this. I recognize that there's some potential validity to these 15 counts, and I'm going to tell you what your potential issues are, Mom, about this. Because part of these are multiple possible counts. The court could find that you've committed more than one offense of contempt on each of these counts. Ms. Roberts has broken them down into 15. If I were to find that you were in contempt of all 15 of those counts that they've put forward to the court, which I'll have to have an evidentiary hearing to determine that, which I'm going to grant your order to show cause for evidentiary hearing in this matter, I want you to understand your repercussions, Mom. The court can order 25 days in jail for every violation, plus and or up to $500 sanction for each and every violation. When I multiply the 25 days times 15, that's 375 days in jail. Is the maximum I can sentence. Well, it's actually not the maximum, because if I find multiple counts within each one, I could put for each one of those. But even if I take the 15 that they've alleged, okay? That's 375 days in jail. Do you recognize that, Mom? Like, there's ways for you to prove whether you had the ability to do certain things. Part of the issues on paying for the orthodontics and the eyeglasses on those things, it depends on if that's willful or not, and you'll have to be able to, you'll have to prove that it wasn't willful. So they have to find that you've willfully committed these acts, okay? So the court finds that there's a prima facie case for the court to move forward on orders to show cause. I'm going to issue an evidentiary hearing date for that. Then we can do that. We can do it January 2nd, counsel. Is that far enough?
So I think I'm back in town then, Your Honor.
Okay.
My calendar real quick. I'm gone in Michigan.
Or I can put you on a stack 2. That would be a stack 1. And then my other ones are in May. I just happen to have that one open for some reason.
I am gone until January 31st, Your Honor. I'm gone for 2
Okay.
weeks.
So now I'm into May, so it's
Now we're into May.
May
Okay.
21st at 1:30.
I'm open then.
Okay. So we will. I'm going to sign it. But you've got a date on here, I believe, counsel. Let me find that line.
At 1:30, is that what you said? I'm sorry.
I did.
Okay.
I'm sorry, what was the date again?
No, it'll be right here. May 21st, you said?
And then no calendar call.
There will be a calendar.
So May 21st at 1:30, and then the calendar call is going to be May 14th at 11 a.m.
Okay, here's her order show cause. Okay, so let's talk about, so that's the issue. I want you to understand what your issues are, Mom. maybe you ought to talk to council, see what you guys can do and what we can. I believe Miss Roberts can be reasonable about getting, if they felt like you were getting the help you needed to help the boys, that could go a long way on having them agreeable on to remove some charges or whatever. I don't know. I'm not going to tell you how to negotiate, but I'm just suggesting that you reach out and you talk to them about that. So let's talk about what I need to do to protect the boys right now. That is my primary concern, is that I need to figure out a way to protect these boys. Counsel, you're suggesting Donna Wilburn or someone like that. I don't think Donna's house is the right place for these boys, but I don't think I can trust Mom right now. The fact that she's sending text messages right up until recently after she received this motion is concerning this court. My concern is I don't know what her mental health is and whether she needs this through a therapeutic setting with the boys.
So the other option, Your Honor, and I didn't talk to my client about it, but I would make him do it as cooperative. She could meet him in a public place, like for dinner, and he could be the supervisor. I know financially, because I don't really know what's going on. The financial disclosure form looks kind of suspect to me, but I'm not gonna. So.
But she did just start at that job, so it's possible she's building the clientele, but you know.
So the other option is that I could have my client or his spouse meet them at a public place. She could have dinner with them or something where there was, to supervise them until we get somebody in place. I don't know what other.
Is there anybody else that that on her side that you trust?
So Grandpa and Grandma were involved in the litigation at one point.
So they're not a good supervisor then.
And there's really nobody else here that they could use as a supervisor.
Your Honor, please don't. Please.
Mom, you've left me no choice. When I listen to recordings like that and I hear text messages, I don't have a choice, but I have to protect these boys.
This is more damning to the kids.
This is temporary until we can get you some help and figure out where we are with the boys.
Your Honor, I'm begging you. Please allow. I won't.
I can't trust you. You already had an order to show cause against you previously, Mom, and you didn't learn from that one, right? I have to protect the boys. So, what's your other suggestions, counsel?
They could do it in a public place, may I say, I have a conference room, she can bring board games and food in the afternoon if she wanted. My staff are there. We could contact Donna Wilburn. I've been using a therapist named Sandy Miller. She might be able to help. Nick Ponzo, I just don't know resource-wise what Mom has to be able to help contribute to that.
Mom, they've given you several options, and they're trying to come up with options that don't cost you because of your financial circumstance. Ms. Roberts is saying it can be in her conference room, that Dad would supervise, Stepmom would supervise, they're both willing to do so. Or you can seek, either we can have Donna Wilburn, she's a therapist, or Nick Ponzo, he's a therapist. These are therapeutic settings. Which would you prefer, Mom?
A therapeutic setting.
Therapeutic setting? Then you have to pay for it. Can you do that?
I will figure a way out.
Okay. My concern is that Mom, I'm going to task you with contacting either one of those people or any therapist. I think you're okay with any therapist, aren't you, counsel, as far
as long as they have some kind of understanding of what their role would be. That's the problem. We just use.
Right, that's true.
So I'll get Sandy Miller, Keisha Wyfer would be fine if she would do it. Donna Wilburn would be fine. Nick Ponzo. I'm trying to think of who else is an MFT, not a.
What if we do this, counsel? What if you give her at least 3 names, and then she can pick from those. She can call them, and she can vet them to set it up. My concern is we set the evidentiary hearing for the order to show cause. Along with that, I assume my concern is that you've asked for just that, but my concern is custody of these children. It needs to be, so temporarily I'm going to grant Dad sole legal and sole physical custody of the boys pending the outcome of the order show cause and the damage she's done to them. I need to know that I want them in a safe setting. I can't have this. When you're talking to children like that, you can't do it. And the fact that you don't recognize you're hurting your children is concerning me more about your mental health, Mom. So that's where I'm more concerned about.
Until we get, I know she wants to do it in a therapeutic setting, but until we get it set up, because it could take weeks.
Right.
I really think that she should have some contact
I
with
agree.
them. So
I
either
agree.
come to my office, I can set up a device that'll record them, that nobody's in the room with them. Something so she's having contact with them. I don't think she should have no contact with them. Even
I agree.
Donna's house on a temporary basis until we can get the therapeutic setting set up.
I agree, counsel. Look, Mom, I understand this is upsetting to you, but I don't have much choice but to protect these boys after I listen to such audio recordings of it. But she's saying that you can also have other visitation. We don't want to wait for that. Do you understand that? Because getting that set up, I don't know what those schedule of those therapists are. They might be booked out a few weeks, and we don't want time to go away without you seeing the boys every week. Counsel, I at least want her to have at least 2 visits a week somehow. That we come up with a minimum of 2 visits a week.
Okay.
In a setting like that. Move forward. The other thing is, Mom, look, I need to know that you're getting some help for this. I would, when you talk to those therapists, perhaps with the therapeutic setting, we can incorporate that she has to have some communication where she knows how to properly talk to these boys. It's clear to me that she's lacking the tools. I don't think she's intentionally trying to be a horrible mom or anything like that. I don't believe that at all, Mom. But I do think that you aren't recognizing that you've hurt these children when you say those kind of things. You need to add a filter to your life a little bit if you're having trouble with that. But now maybe when you look at these boys' faces and you realize that if you say something bad about him, you're saying something bad about them, maybe you will get that now. Maybe you haven't had that opportunity. But my temporary order of sole legal sole physical custody with supervised visitation until we have an evidentiary hearing on this matter. I need, like I said, a minimum of 2 days a week. If the therapeutic setting can only happen one day, then the other day has to be some other way, whether it's with somebody else. I want to make sure that these boys have regular contact with their mom.
Okay.
So as far as, let's talk about what are we going to talk to the boys about, because they're going to be confused, and because we have EDCR 5.301, it kind of puts, so we need to have a conversation that you can blame it on the court. Mom, you can blame it on the court as well. I'm fine with both of you blaming it on the court, but that the court insists on court rules where you don't discuss court matters with children. So with that being said, I can say, look, the court was concerned and wants to protect them.
Your Honor, what about my vacation time with my kids? Please, it's our holidays.
So
that's
she just noticed a vacation with them December 6th through December 20th. I don't think she can take a portion of that because it would be during school. But she just noticed that vacation request according to my client.
What's the vacation plans, Mom, during school? You can't take them out of school?
I just want to be able to have them with
So you
me.
wanted a staycation. You were going to do a
Pretty
staycation,
much.
make sure they go to school. My concern, Mom, is I don't know that I can trust you at that point.
Your Honor, I can have something recorded the whole time. I can be in the public, whatever it is. I just want to be able to spend holidays with my children.
Yeah, I want you to be able to too, but I need to be able to trust you're not going to hurt them and scar them emotionally more than you already have. These text messages you've involved Mark especially so much in this. You are hurting him so badly by involving him in litigation.
Your Honor, if she could get some kind of initial evaluation by like Dr. Holland or
Okay.
Peggy.
We're trying to come up with I think if we can get an evaluation by then she can counsel your client's
I don't
agreeable.
want her to have
That
14
long.
days with them. Like maybe she could have
But
like
Your Honor,
a day, like where she has them alone. If the evaluation comes back and there's no substantial issues, maybe we could talk about it then. That would still give us about 6 weeks. She could probably get in with somebody. I think Mark Chambers is still doing it. Paglini does it. Dr. Holland does it. Dr. Ahmad does it.
Are you writing any of this down, Mom? Because we're trying to give you those.
I'm sorry.
I can send it to her. in an
Okay,
email.
so you'll send it to her in an email, counsel, that says, look, these are some. Look, if you'll get an evaluation that says that one, and that I want them also to explain to you about damage. I want to make sure whoever she goes to explains it more to her about the damage that this kind of alienation of parental alienation or pathogenic parenting does to children. Whatever our phrase is of the year.
Okay.
That she has to understand it, and that they feel like they can trust her to do that. I need them to feel like they can trust. See, we need somebody to say we can trust you, Mom. Because even after you got in motion, you still sent them text messages and said, delete this, delete that, delete this. Your excuses for it aren't really holding truth to me after listening to the audio recordings. So I am worried about your boys. So with that evaluation, she can have part of her vacate, maybe a week's time. I don't want 14 days is a long time. Because they can't be out. They can't be out of school anyways, Mom.
I know.
They don't even get out of school until.
But he took his vacation time earlier.
Do you know what day the kids get out of school for
I'm
winter
looking
break?
at her, sorry. Yeah, I think they get out the 20th. Correct?
Yeah.
So they don't even get out till the 20th. So she was trying to take school weeks. She's not even allowed to do that under the plan.
Under the plan, no, she can't take.
Yeah.
You
So
understand?
I
you can-
agree she should have some Christmas time. Either
Definitely.
if we can't get the evaluation back, Christmas Eve I'll make my client supervise some time with her.
Well, make sure you have some time there, please.
Yeah.
I was supposed to get the winter break this year with them.
Right. But I need some evaluator that says you can control yourself. and that you've had enough conversation, that they've evaluated you, that they think you're okay, and that maybe all you needed was a talking to by this court. That's what I'm hoping comes back, Mom, because I don't like you being without your boys. But you're the one who did this, Mom. They warned you, like, I am sure that you had a lot of communication from Miss Roberts about this, right?
Yeah, well, I guess.
Yeah, and you didn't curb that behavior. That's my concern. Counsel, if we can get an evaluation that says it, then I want her to have at least some part of the winter break without it having to be supervised for that amount of time. But look, if anything happens more, then her visitation would end up remaining supervised for a very long time, Mom, if I can't trust you not to damage the boys. So that's my concern. So, Counsel, so the issue is she's got to get an evaluation.
Can we set a return hearing, Your Honor,
You bet.
before we leave for vacation, just so that we can get it?
You bet. Can we?
I'm leaving, I think I'm leaving the 20th of December, so maybe we could do
So
it.
before the 20th of December, see where we're at. I would like that as well, because then I'll know where we're going for Christmas, Mom. What we're doing about that issue. I'm gonna have to overbook council, so it'll mean that maybe everything will be delayed. But I understand that everybody's just gonna have to deal with it during that period of time for the winter break stuff. Let's see what it's, oh, and I'm gone. I'm gone the 18th or the 17th, 18th, 19th, and 20th for a wedding.
Okay.
Who gets married on a Wednesday? I don't know. Go ahead.
I won't be there, I'll already be in the shade.
She'll be gone already.
Oh,
Sorry, I leave
She'll
the
be gone
20th.
already. Is there anything in the beginning? Let's see what we have that I can put in. I have an order shortening time rejection on 9 o'clock on the 12th. Do that one? We could do that one, 9 o'clock on the 12th. Oh, I only have one return set on that day too. That's weird. Yeah, let's set it at 11 on that. And then I gotta go, okay, that's fine. It's good, though. What date was that? Just
okay,
moving
so
forward.
it's going to be on December 12th at 11 a.m.
Okay.
December 12th at 11 a.m. We'll return from that. I signed your order show cause council with the date on it. But we'll give that to you from home already. Mom, look, so Miss Roberts is going to get you some names of the evaluators, so pick one. Get a call into them immediately so you can get in and be evaluated so that they can have a conversation regarding it and that they can clear you and feel like you're more safe, that you understand the ramifications if you do anything like this again. The conversations with the boys need to be about fun things in the boys' lives. You have them keep focusing on this divorce and you're going to continue to scar them. So I need everybody to have them focus on their future and their lives, not about your guys' drama. So that will be my order, council. So we'll have that at the same time. We'll set up the visitations as soon as we
That's
can.
fine, I'll communicate with her today about all that.
Okay, and-
Just for clarification, he will tell the boys that the court wants to protect them at the present time, and therefore they're going to be with him on a temporary basis.
Yeah.
Until Mom gets help, or what do you want him to specifically say?
Well, I think, and you say until Mom gets cleared.
Okay.
Maybe we say cleared. I don't want to make it feel like also that you know, I want to say, look, that the court wants to feel confident. My mom getting cleared.
Okay.
That they're gonna be.
Okay.
Yeah.
I just want to be clear.
I want it
on
to
what
be
he says.
vague. We're all trying to protect those boys, and that's the level of protection I need you to learn, Mom. You know, you have Matthew that is much younger. He's only 9. So I need you to realize that you have a while to go on this, and you need to learn those skills, whatever it is, if that's the problem. I don't know what the problem is, but I've set the evidentiary hearing council for that. If you'll prepare the order for today and get everything, and then we can move
clarify
forward.
with Mom that the children are at school today?
Are they at school today, Mom?
Okay, so my client will
Okay.
get them from school today.
Get them from school today, please.
Thank you.
Okay. Thank you for your appearances.
Thank you.